Hello, everyone. Welcome to the Canada Truth Channel, where Canada, the illusion of freedom and system of control is exposed. Today's video, what Alberta separation means to the treaties. Let's go. First off, the propaganda ministry, as you can see, is hard at the propaganda regarding First Nations people claiming Alberta has no right to secede. Okay, the last video I showed you actually what the treaty said. However you may feel about it, it is what it is. Those are the facts in law, okay? Moving back to the treaties, provided, however, that Her Majesty reserves the right to deal with any settlers within the bounds of any lands reserved for any band as she may see fit, and also that the aforesaid reserves of land or any interest therein may be sold or otherwise disposed of by Her Majesty's government for the use and benefit of the said Indians entitled thereto, with their consent first had and obtained. Okay, that's the consent part. No one is trying to sell or dispose of that reserved land. Of course, First Nations people will be consulted during this whole process. However, as for rights to the land, as I've shown you in the last video, all rights forever were ceded. So it is what it is. It is further agreed between Her Majesty and her said Indians that such sections of the reserves above indicated as many at any time be required for public works or buildings of what nature soever may be appropriated for that purpose by Her Majesty's government of the Dominion of Canada, due compensation being made for value of any improvements thereon. So no one's trying to take your land. You do not have the right to that land any longer. I'm sorry, First Nations people. I wasn't there when these treaties were signed, nor were you. But the fact of the matter remains, this is the truth. This is what the treaties actually say. I've covered all this in previous videos as well, but while I'm at it, I'm going to explain how this affects treaties and the province. So here we have the Constitution Act 1867, formerly known as the British North America Act 1867. I will remind everyone that the British North America Act 1867 constituted a central government for the united colony of the British Empire. It was not ever a constitution by the people of Canada for the people of Canada. Let's be clear. Now, if we look, we notice that the enacting clause is missing. We click on the endnote, the first endnote, and we can see the enacting clause was repealed by the Statute Law Revision Act 1893. It read as follows: Be it therefore enacted and declared by the Queen's most excellent Majesty, by and with the advice and consent of the Lords Spiritual and Temporal and Commons in this present Parliament assembled, and by the authority of the same as follows. No longer enacted. It could never be reenacted. Section 2 was also repealed. by the Statute Law Revision Act 1893, read as follows. The provisions of this act referring to Her Majesty the Queen extend also to the heirs and successors of Her Majesty and kings and queens of the United Kingdom of Great Britain and Ireland. So the provisions of the British North America Act after the death of Queen Victoria in 1901 no longer extended to her heirs and successors. Let's go back and see what that actually does. Section 3, Declaration of Executive Power in the Queen, Queen Victoria. The executive government and authority of and over Canada is hereby declared to continue and be vested in the Queen, Queen Victoria. She died in 1901. The provisions of the British North America Act no longer extended to the heirs and successors of Queen Victoria. Okay. Now, I've covered the other shenanigans regarding our constitutional issues in Canada, and I've also covered the Statute of Westminster in depth in previous videos. Please watch them. However, why in 1931 Canada chose not to exercise its full autonomy as provided for under the Statute of Westminster? I can tell you why. It's because the government of Canada did not want to lose their power, their pensions, their ability to rape and pillage the people of Canada and the land of Canada for our resources and money. The Statute of Westminster gave autonomy back to the provinces. Let's see what it actually says. I encourage all of you to use the links I provide and read the absolutely ridiculous excuse that is provided by the Canadian government. Anyways, the sections of the Statute of Westminster that pertain to Canada are section number 2. We'll review all of them. Validity of laws made by Parliament of a Dominion. The Colonial Laws Validity Act 1865 shall not apply to any law made after the commencement of this act by the Parliament of a Dominion. No law and no provision of any law made after the commencement of this act by the Parliament of a Dominion shall be void or inoperative on the ground that it is repugnant to the law of England or to the provisions of any existing or future act of Parliament of the United Kingdom or to any order, rule, or regulation made under any such act, and the powers of the Parliament of a Dominion shall include the power to repeal or amend any such act, order, rule, or regulation insofar as the same is part of the law of the Dominion. So there's where it states it gives authority of the Dominion of Canada to make its own laws. Next we have the power of Parliament of Dominion to legislate extraterritorially. It is hereby declared and enacted that the Parliament of a Dominion has full power to make laws having extraterritorial operation. Moving right along, section 7. Saving for British North America Acts and application to the Act to Canada. Nothing in this Act shall be deemed to apply to the repeal, amendment, or alteration of the British North America Acts 1867 to 1930 or any order, rule, regulation made thereunder. Excuse me, the provisions of Section 2 of this Act extend to the laws made by any of the provinces of Canada and to the powers of the legislatures of such provinces. The powers conferred by this act upon the Parliament of Canada or upon the legislatures of the provinces shall be restricted to the enactment of laws in relation to matters within the competence of the Parliament of Canada or any legislatures of the provinces respectively. Now, all the constitutional experts out there say Section 7 negates the effect of the Statute of Westminster on Canada, because Section 7 states that we have no power to amend the British North America Act. Once again, the British North America Act was a private bill by the Imperial Parliament of the UK on behalf of Queen Victoria, and no one in Canada ever had any authority to change or repeal anything. Only the British Parliament on behalf of Queen Victoria had that authority, which continued even though his heirs and successors no longer had any executive government or authority of or over Canada. Now, any of you lawyers or constitutional lawyers or members of the government that want to debate this, please, I've had discussions before, and I've got either people looking like they've soiled their trousers or nonsense arguments with zero facts or evidence. So if anyone wants to debate any of this, please bring your facts and evidence that meets the standard of evidence, and let's talk about it. Show the people of Canada how this is not correct. Meaning of colony. Notwithstanding anything in the Interpretation Act 1889, the expression colony shall not in any act of the Parliament of the United Kingdom passed after the commencement of this act include a dominion or any province or state forming part of the dominion. No longer a British colony. The autonomy went back to the provinces. The executive government and authority of and over Canada no longer extended to the heirs and successors of Queen Victoria. Once again, they just didn't tell the people of Canada. So the land went back to the people of the provinces, and the treaties, by default, fall on the provinces because the federal government no longer had lawful authority of or over Canada on behalf of Queen Victoria. Make sense? So all the power went back to the provinces. Existing treaties by default would be the responsibility of the provinces. Okay? Now let's look at international law. Here we have United Nations Treaty Collection and the Vienna Convention on the Law of Treaties. Now moving down, we can see Canada didn't sign this treaty. However, a cession A, secession D, and a ratification on October 14th, 1970. Now let's look what it actually says about Canada. In acceding to the Vienna Convention on the Law of Treaties, the Government of Canada declares its understanding that nothing in Article 66 of the Convention is intended to include the jurisdiction of the International Court of Justice, where such jurisdiction exists under the provision of any treaty in force binding the parties with regard to the settlement of disputes in relation to states parties to the Vienna Convention, which accept as compulsory the jurisdiction of the International Court of Justice. The Government of Canada declares that it does not regard the provisions of Article 66 of the Vienna Convention as providing some other method of peaceful settlement within the meaning of paragraphs 2A of the Declaration of the Government of Canada, accepting as compulsory the jurisdiction of the International Court of Justice, which was deposited with the Secretary General of the United Nations on April 7th, 1970. Let's see what they're talking about. So here's Article 65, with procedure to be followed with respect to invalidity, termination, withdrawal, or suspension of the operation of a treaty. So it has the provisions here. Canada talks about Article 66, 2A. Any one of the parties to dispute concerning the application of the interpretation of Article 53 or 64 by written application submit to the International Court of Justice for a decision unless the parties by common consent agree to submit the dispute to arbitration. So we're not actually signed on to this treaty. However, there is existing international law. And if Alberta does separate, Alberta would likely sign on to this treaty and transfer all of the treaty provisions from the de facto federal government to the provincial government. And those responsibilities, I'm sure, would be fulfilled much, much better, in better faith than the federal government historically has. I hope this helps clear it up. Once again, any constitutional experts or lawyers that want to discuss any of this or say claim what I'm showing people is nonsense, bring your facts and evidence that meet the standard of evidence and let's have a discussion. Otherwise, my claims stand undisputed, and they are facts in law, and they are provable in law. So there you have it, ladies and gentlemen. It is what it is. Stay tuned for the next video. Please like, share, and subscribe so this information gets out there. Thanks for watching.